Jen Taylor? Remind me to give you Jen Taylor's email address. She's the one who coordinates our trip for the embassy. She's the one in charge of this visit. And you guys should work on it. Well, Burr is the Bureau of Economic Regulation. It used to be their trade. It's essentially their NTIA. Lord Carter was what used to run Ofcom. Well, he used to work. Then ran Ofcom, and now is running, which is their FCC. Now running NTIA. Very impressive guy, very smart. The way they do these things is to be a minister to have that position, so they made him a lord. He's not.
And only lords can do that.
I think that's right.
You know, we did it the right way.
Look, that we realize get more for our money. Oh, they're good. They're like, I wish we'd they're saying it's going to be 2012
Yeah.
before they're really done. And
That's pretty different.
but no one I think people are going to be pretty jealous that they're not. They may not have the growing pains and political sniping we had to go through, and the sort of arm twisting we had to go through, and sweating we had to go through. They're all jealous that we're going to
Right. Can I pull this one out?
I don't know what that does. Are you sick? I guess it's not the recess meeting you got at home, right?
Yeah. Should, right? Not very exciting. Look at this. Small crowd. I actually read your memo. The question, or the question I have for Wendy Mood. Hi. See, oh my pleasure. Yeah. The .NET people who manage
Yeah, that does.
but I just thought one had one domain name. They might have like one may have some .NET.
Like VeriSign is the only company that has an exclusive agreement for like a .com or .GoDaddy, while the sell there's only one registry for Apple.
Okay.
VeriSign is the .com. Someone else is the .biz.
But that wasn't clear.
But they're a wholesaler, so then
Oh, so they can resell back to the.
And so they fight over who gets to be the wholesaler as well as who gets to be.
So then
That's
there
what
are
was
a
confusing.
number.
I thought the memo was confusing. I just didn't know that. Because they had both had .NET issues.
Right.
And I was like, oh, I thought they were one.
So GoDaddy.
Okay.
But as they put out the new top-level domains, other companies to be the VeriSign for that.
Wholesale.
did, I mean, they did. Yeah. Can I just say, that's what I want to make, the fact that we have an administration.
Okay, I'm here, Rick. We can start.
Yeah. Sir.
Sir John. Are we waiting for our ranking? Just waiting for the coffee. Not really stalking you.
I thought maybe you had your back.
No, coffee's more important.
I had mine 5:30 this morning.
Really? I was sleeping at 5 minutes.
Early to bed, early to rise. Makes a man healthy, wealthy.
Yeah, are you wealthy?
No.
2 out of 3. ain't bad.
I wish. Good morning, John. Good.
The subcommittee will come to order. Our discussion this morning focuses on the activities of the Internet Corporation for Assigned Names and Numbers, commonly referred to as ICANN. Since 1998, ICANN has managed the designation and allocation of Internet domain names and addresses under various contractual arrangements with the United States Department of Commerce. The original Memorandum of Understanding that was signed in November of 1998 has been renewed on several occasions, most recently as a joint project agreement, which is now scheduled to expire on September 30th of this year. One matter upon which we will focus this morning is whether Department of Commerce oversight should be retained through renewal of that agreement, or in the alternative, whether the time has come for that oversight to be relinquished and for ICANN to operate after September 30th without supervision with respect to the allocation and designation of Internet domain names and addresses and associated functions. It should be noted that under a separate contract which is not scheduled to expire, the Department of Commerce has conferred upon ICANN the management of the master files of the domain name system, generally known as the root zone files. Under that non-expiring contract, ICANN also manages and coordinates the allocation of IP addresses. In considering whether the expiring contract should be renewed or should expire without renewal, key questions are whether ICANN's decision-making is sufficiently transparent or whether improvements are needed, and whether under its existing structure and practices, ICANN is sufficiently accountable to Internet stakeholders and the global community of Internet users. I'm sure that today's witnesses and members of this panel will have a number of views to express, and the members will have questions about those key matters. A second focus of today's hearing is on ICANN's proposal to introduce new generic top-level domains which could involve descriptions of various types of activities, locations, brands, or trademark names. It's suggested that the creation of new top-level domains would promote competition among registry operators of the TLDs and would enhance consumer choice. Among the concerns that have been raised about a proliferation of new TLDs is the cost to companies associated with protecting their brands if they have to purchase additional second-level domain registrations under the new top-level domains. Not only do they purchase their exact brand names as a common practice under the various TLDs, but they generally also purchase common misspellings of their brand names in order to protect the brand name itself. So a buffer area, in effect, is acquired around that brand name through the second-level TLDs. So as the number of top-level TLDs grows, the cost to companies to protect their brand names grows exponentially. Does the added competition and consumer choice that would arise from the new TLDs offset that cost as a matter of public policy? A key question for us to consider. Other questions relate to ICANN's capacity to manage all of the new top-level domains and assure the overall stability and security of the domain name system, and whether ICANN can assure that an adequate amount of competition would in fact arise in the bidding process for new TLDs. We will welcome our testimony this morning. We thank our witnesses for being with us and sharing their views on these very important subjects with regard to the future of Internet management and governance. And at this time, I'm pleased to recognize the ranking Republican on our subcommittee, the gentleman from Florida, Mr. Stearns.
Good morning, and thank you, Mr. Chairman. For more than a decade, ICANN has played a vital role in maintaining a stable and reliable Internet, and I think that's a very high achievement. ICANN has the critically important responsibility for managing the domain name system. The hierarchy of IP addresses and associated domain names that enable Internet users around the globe to communicate with each other. ICANN has succeeded, both because it has been a private sector-led effort, not controlled, for example, by the United Nations or any other government, and thanks to the advice, guidance, and engagement of the United States through a series of arrangements, including the Joint Projects Agreement. The key question before this committee is, will the expiration of the JPA in September put the stability and security of the Internet at risk? I have some concerns and want to hear from the panel on this matter. The JPA with the Department of Commerce has played an important role in ensuring that ICANN is accountable for its decision and conducts its mission in a manner that provides for stakeholders' participation. The JPA should be extended, and the NTIA is in the process of seeking public comment on this issue. One major question for this hearing is whether there is a need to renew the JPA when it expires and what the nature of U.S. engagement with ICANN would be in its absence. While it can never please all its stakeholders all the time, it needs appropriate governance mechanism that will ensure its openness and accountability. Apart from ICANN's agreement with the Department of Commerce, what other external mechanisms are in place today to simply safeguard that accountability? If there are none, or if there are insufficient controls, perhaps ICANN's ongoing relationship with the Department of Commerce should then continue. Ultimately, though, through the global Internet community, we'll need to develop an appropriate governance structure to ensure its accountability. One of its functions is to create generic top-level domains, or gTLDs, which is a unit of letters or words beyond the rightmost dot, such as .com or .gov or .net. Over the time, the number of gTLDs has expanded to 21. Last June, ICANN proposed to further expand the number of gTLDs. Under the proposal, which was put out for public comment and must be finalized and approved by the Board of Directors, new gTLDs could include the names of organizations, companies, locations, or additional generic words. However, before ICANN expands this list, it should address concerns about the proposed expansion and provide further opportunity for comments by all the stakeholders. In a letter to ICANN last December, NTIA raised a number of questions regarding the way in which it was proposed to administer the rollouts of these new gTLDs. Specifically, NTIA wondered whether it is prepared to implement measures to promote competition on registry prices, terms, and conditions, ensure the application process with respect to national and international laws, including intellectual property rights, enforce contract compliance, and design a rational fee structure. NTIA recommended that ICANN can resolve a number of these issues before expanding the gTLDs. My colleagues, trade holders are concerned that without sufficient protection for intellectual property rights, they will have to engage in costly defensive registration of domains that are identical or similar to their trademarks across gTLDs to prevent others from registering them or pursue costly and time-consuming administrative or legal processes against cyber squatters. I hope our witnesses will address these legitimate concerns also. Another and final point, that since ICANN is considered a not-for-profit organization, does a transparent mechanism exist to address any excess revenues? According to data from the Technology Policy Institute, its revenues have increased from $5 million in 2000 to over $60 million in 2009, while expenses have increased from under $3 million in 2000 to over $54 million in 2009. Thus, it will have a surplus of close to $7 million from FY 2009. ICANN's largest expense is personnel, accounting for close to $20 million of the $54 million. According to its annual report, it employs 100 staff members. Although salary information and administrative costs were not available, I hope witnesses today will address these issues on finance. Thank you, Mr. Chairman, for holding this hearing.
Thank you very much, Mr. Stearns. The gentleman from Pennsylvania, Mr. Doyle, is recognized for 2 minutes.
Thank you, Mr. Chairman, and I want to thank you for holding this important hearing. I own a few domains, and I've benefited from the competition among domains and who I can buy them from. I believe that because the Internet is truly global, significant input from around the world is important to its governance, which is why it pains me to say that I hope that the Department of Commerce continues the JPA with ICANN and not relinquish control at this time. I'm afraid ICANN seems better at furthering its own interest than those of the millions of Internet users that it's supposed to look out for. My constituents are still receiving misleading solicitations that look like invoices from a registrar, despite a court injunction and despite FTC intervention. Why does ICANN allow them to continue to sell domain names? This is domain slamming, and it continues today. When ICANN attempted to curb the abuse of domain tasting, the 5-day window when purchased domains were able to be returned and refunded, their solution was to make their fee non-refundable. Well, that helped curb the abuse, but the money didn't go for consumer protection or coordination towards IPv6. It went to the general budget, executive compensation, and cushioning ICANN's $4.6 million stock market loss last year. If they can afford to lose that much money in the market, why are they collecting the fees from us in the first place? I'm glad to see witnesses talking about the gTLD issue today, which I have grave reservations. I fear that the primary beneficiary is not the consumer, who might suffer from increased confusion, or the businesses who would need to register new domains to defend their trademark across a near infinite number of top-level domains. On the other hand, it might act as a needed market-based solution to ensure that rates and fees for .com are kept low in this economic downturn. Small domain users like me and companies that need and use thousands of domain names to run their businesses, and the tens of millions of Internet users who place their trust in the Internet today need assurance that someone is looking out for them. I don't see it from ICANN. Thank you, Mr. Chairman.
Thank you very much, Mr. Doyle. The gentleman from Illinois, Mr. Shimkus, is recognized for 2 minutes.
Thank you, Mr. Chairman. We have a new administration. Everyone knows we have a new individual getting close to be confirmed in NTIA. We have a change in the administration at the ICANN. This is now not a time to make changes. I would be supportive of extending the joint project agreement. I look forward to the hearing, and I yield back my time.
Thank you very much, Mr. Shimkus. The gentlelady from the Virgin Islands, Ms. Christensen, is recognized for 2 minutes.
Thank you, Mr. Chairman and Ranking Member, for this hearing and for giving me yet another list of new acronyms to add to others that I'm still trying to haven't committed to memory, but I'm beginning to understand the concepts, and that's more important. We're here to review the progress ICANN has made and whether it's ready for the joint project agreement to expire on 9/30/09 and for the management of the DNS to transfer from the MOU with the U.S. government to the global community, whether it's fully able to meet its mandates and the goals of stability, competition, bottom-up coordination, security, and broad representation, as well as transparency. There seem to be many concerns that it's not ready, and we need to determine if this is just a fear of the risk that any change would bring, or whether there are legitimate concerns that still need to be addressed first, as some panelists will suggest. I'm particularly interested in the bottom-up coordination and, of course, security, as well as understanding whether the projected plans ICANN has are not only realistic but responsible, and whether or not they jeopardize stability and security. I want to applaud our chair and ranking member once again for the excellent oversight and yet another pressing issue, and look forward to the testimony that will be presented. Thank you, everyone, for being here and sharing your views with us on this issue.
Thank you, Ms. Christensen. The gentlelady from Tennessee, Ms. Blackburn, is recognized for 2 minutes. She was here a moment ago. All right, we'll await her arrival at a later time. The gentleman from Nebraska, Mr. Terry, is recognized for 2 minutes.
Thank you, Mr. Chairman, and appreciate you holding this hearing on what I believe could actually be a matter of national security. ICANN serves a very important role in being responsible for managing the domain name system, which, as you know, is the hierarchy of IP addresses and associated domain names that enable Internet users around the globe to communicate with each other. This interconnectedness that allows us to communicate with one another is the reason that ICANN should renew the joint project agreement or sign a similar agreement with the current when the current agreement expires later this year. The goals of the JPA should continue to work towards increasing ICANN's transparency, accountability, and openness while developing mechanisms and procedures to transition the domain name system functions to the private sector in a manner that promotes stability, security, competition, bottom-up coordination, and representation. Should a rogue nation get the chance to control the DNS, it's is definite possibility that they could use it to harm the U.S. or to dismantle and interfere with our ability to communicate globally through the Internet. I would hope that my colleagues would join me in saying that, quite simply put, the United States government created the Internet and it needs to be in charge, as we could very well be vital to our nation's security. Thank you, Mr. Chairman, and I yield back my time.
Thank you very much, Mr. Terry. The gentlelady from Florida, Ms. Castor, is recognized for 2 minutes.
Well, thank you, Mr. Chairman, very much for calling this interesting hearing on the Internet Corporation for Assigned Names and Numbers. I appreciate the witnesses' willingness to be here today to discuss these important business issues and consumer issues and how we continue to modernize the Internet. I yield back the rest of my time.
Thank you very much, Ms. Castor. The gentleman from Michigan, Mr. Upton, is recognized for 2 minutes.
Thank you, Mr. Chairman. I would just like to say that I, too, join many of my colleagues hoping that the JPA can be extended in a timely fashion, and I look forward to being a partner in that. I believe that it will be certainly a bipartisan one as well. Since we have Ms. Alexander here, we have a pretty big date coming up on a little bit more than a week away here, and you may expect to have some questions on the transition to digital just to see where we are. I know a lot of Americans are concerned about that. It don't have quite the publicity we had back in February, but we all hope that it'll be a pretty smooth transition. We look forward to your thoughts about that as well. Mr. Chairman, I yield back.
Thank you very much, Mr. Upton. The gentlelady from California, Ms. Matsui, is recognized for 2 minutes.
Thank you, Mr. Chairman. Thank you for calling today's hearing. I applaud your leadership in addressing this important issue. I'd also like to thank our panelists for being with us here this morning. As we all know, ICANN was created in 1998 to govern the allocation and designation of Internet domain names and addresses. Although certain responsibilities for the domain name system were transferred from the Department of Commerce to ICANN, the Department of Commerce continues to exercise limited oversight of ICANN through the Joint Project Agreement. Under this agreement, the Department of Commerce affirmed its policy goals of preserving the security and stability of the Internet domain name system. This agreement is now set to expire on September 30th of this year. While I understand some of the reasons that ICANN does not want to extend the JPA agreement, such as how the U.S. role is viewed abroad, now may not be the time to say that ICANN should be on its own. Just last year, NTIA initiated a review of the agreement and found that although ICANN has made progress in key areas concerning security and stability of the domain system, important work still remains. We must ensure the Internet domain system is transparent, accountable, and has a strong governance structure. Moving forward, I urge administration to carefully consider its agreement in partnership with ICANN. I thank you, Mr. Chairman, for holding this important hearing today, and I yield back the balance of my time.
Thank you very much, Ms. Matsui. Ms. Blackburn hasn't returned. The gentleman from the state of Washington, Mr. Inslee, is recognized for 2 minutes.
Thank you. I'll reserve. Thank you, Mr. Chair.
Thank you, Mr. Inslee. You will have 2 minutes of time added to your questioning period. The gentleman from California, Mr. McNerney, is recognized for 2 minutes.
Thank you, Mr. Chairman. This is an interesting and important hearing, so I'm looking forward to it. It's important to work together to ensure that we have a fair and transparent system, maintaining and improving the Internet in order to avoid potential difficulties. It's essential that we keep the Internet accessible and easily navigated to all, and I look forward to the testimony this morning. Thank you.
Thank you, Mr. McNerney. The gentlelady from California, Ms. Eshoo, is recognized for 2 minutes.
Thank you, Mr. Chairman, and good morning to all of the witnesses. Like any new organization, ICANN has gone through its share of growing pains. And since it was created 11 years ago, it has been a target for criticism among the global Internet community. I'll have some questions today about the operation and where you are right now, but I do think that progress has been made, and that, and on the other hand, that many of the concerns I think have been appropriate, and ICANN continues to develop itself and to do the thorough oversight over the technical and administrative functions under its jurisdiction, and that's a plus. I think that you've been successful in introducing competition to both the retail and the wholesale domain name business, added a whole new host of Internet domains, and stepped in to ensure that the country code top-level domains are properly designated. I think the most important and heavily trafficked domains, .com and .net, are operated by VeriSign, a company headquartered in my district in Mountain View, California, and I know that Mr. Silva is here today, and I welcome him. VeriSign has maintained a 100% uptime for .com. It has never failed. That's something in and of itself, so to be congratulated for that. It's important to remember that ICANN was founded in response to growing concerns about U.S. domination of the Internet. And today, I think many countries believe the U.S. continues to exert undue influence over ICANN and the administrative functions of the Internet. We can talk about that. But I understand the concerns about this whole issue of excessive U.S. control over Internet governance, but the alternative right now I think is clearly unacceptable. ICANN doesn't have the independent authority and the governance structure to prevent other governments from using power over the DNS to interfere with innovation, competition, and freedom of expression. So I look forward to the discussion and the questions that I will ask, as well as my colleagues, and welcome all of you here. And I thank the chairman for having you here today, because I think it's important that you are. Yield back.
Thank you very much, Ms. Eshoo. The gentlelady from Tennessee, Ms. Blackburn, is recognized for 2 minutes.
Thank you, Mr. Chairman. I do thank you for the hearing today, and for our witnesses, welcome. We are delighted that you are here with us. We do have multiple hearings going on this morning, so we are going to be jumping up and down and in and out, but please excuse us for that. Few international organizations quietly wield the power in the global community that ICANN currently wields. While most Americans have probably never heard of ICANN, it is this California-based organization, which is a nonprofit, that is responsible for the management and the assignment of virtually every IP address and domain name worldwide. Wow. That is the growing side of things. It is an enormous responsibility to be overseen by a non-governmental organization. That reason alone necessitates this committee's time and attention to provide proper oversight, notwithstanding the fact that our government's only functional tool for overseeing ICANN activity stems from the JPA. And that does expire on September 30th, which brings us to today. Now, there is a letter from Chairman Thrush, the January 25th letter, in which he states that ICANN does not believe it should answer directly to the U.S. government, and that the memorandum of understanding it signed in November 08 is no longer necessary. And I'm quoting from that letter. Now, many disagree and believe that additional oversight, not less, is necessary to provide a check and balance regarding decisions made by an international organization comprised of unelected officials. The Internet, and this is what is so interesting to me, and I think it's really exciting when you look at commerce and the growth of especially small business commerce. The Internet consists of 174 million websites, 570 million computers, and more than 1.5 billion users. Coordination of this intricate web necessitates transparent decision-making, technical expertise, and even-handed governance. Only U.S.-sponsored oversight for a body tasked with overseeing the domain name and IP address system for which ICANN is responsible can ensure the Internet's continued viability and fairness as 21st century Internet architecture evolves. It is therefore imperative for the U.S. government to remain integrally linked to the organization, thereby securing the historic American role in the development and commercial governance of the Internet architecture. So we're looking forward to hearing from you and working with you. And Mr. Chairman, I yield back.
Thank you very much, Ms. Blackburn. The gentleman from Michigan, Mr. Dingell, Chairman Emeritus of the full committee, is recognized for 5 minutes.
Mr. Chairman, I thank you for your courtesy. I commend you for this hearing. It is very much needed. It is not a new issue. At issue today are a number of matters related to oversight of the Internet Corporation for Assigned Names and Numbers, ICANN. In particular, we will examine the pending expiration of the Joint Project Agreement, JPA, between National Telecommunications and Information Agency, NTIA, and ICANN. ICANN's proposed plans to expand the number of available generic top-level domains, gTLDs, and the future of ICANN's contract with VeriSign for registration of the .com top-level domain. Each of these issues requires a number of careful considerations and ample participations by all affected stockholders before any change in policy is either ratified or understood. I'm not satisfied that this has been the case with the matters I've just mentioned, and this committee has had troubles with these matters before. And I intend to ask such questions of our witnesses as will enable us to get very frank answers about all of them, and I urge my colleagues to do like. Before, however, engaging in a substantive dialogue with the witnesses today, I would like to note the following. First, with regard to the expiration of the JPA between NTIA and ICANN, I wish to reiterate my insistence that ICANN remains far from a model of effective and sustainable self-governance, and I hope they're listening to that comment. Legitimate concerns about the lack of fairness, transparency, and accountability in ICANN's functionings continue to be raised by stakeholders in the Internet community. Particularly in a time of increased cyber attacks on the U.S. government and domestic businesses, I find it wholly unwise to reduce further the participation of the federal government in determining the course of Internet's future development. Similarly, and limited through the oversight NTI exercises over ICANN may be, given the recent observable effects of deregulation and inadequate oversight on the economy, I believe that here we have an analogy. The JPA between NTIA and ICANN should be extended. Second, concerning gTLDs, I consider ICANN's attention to the effect of dramatically increasing the number of available gTLDs on competition, pricing, and consumer choice clearly inadequate. Moreover, I have suspicions that expanding the number of top-level domains could in fact give rise to increased instances of fraud perpetrated on consumers and the practice of cyber squatting, an unhealthy and dangerous situation. Finally, I continue to maintain that ICANN's contract with VeriSign for the register of the quote.com, close quote, domain is characterized by a deplorable lack of transparency. If this is not going to be a government undertaking and it's not going to be adequately regulated, it has to be transparent, which it clearly is not. In brief, I have grave misgivings about the wisdom of extending this contract after it expires in 2012, and I will expect this hearing to produce some answers as to whether or not that should be extended and whether or not it needs to have additional safeguards to assure that it is properly extended with proper transparency or, in the alternative, more regulation. Thank you for your courtesy, Mr. Chairman. I look forward to a constructive discussion with our witnesses today and an answer to the questions which this committee has to ask. Thank you.
Thank you very much, Mr. Dingell. The gentleman from Arizona, Mr. Shadegg, is recognized for 2 minutes.
Thank you, Mr. Chairman, and thank you for holding this hearing today. I want to welcome all of our witnesses, but I particularly want to welcome to Washington the GoDaddy Group and its representative, Christine Jones, whom I've known and worked with for many years. The GoDaddy Group plays an important role in the economy of Arizona. They are a key component of our business community, and they have, I think, great insight and perspective in this particular topic about which we're discussing today. I welcome Ms. Jones and look forward to her testimony along with that of the other witnesses. ICANN has played a vital role in the development of the Internet and has carried a huge burden, but has been adequately expressed here, and I will be brief in my remarks. There are certainly problems, and it is apparent that a great deal of work needs to be done. With the looming expiration of the joint project agreement, it is clear that a plan must be put in place to ensure the security, stability, and viability of the Internet remains intact. I applaud the work of ICANN to date, but I believe there are areas, indeed significant areas, for improvement. Again, Mr. Chairman, I thank you for this hearing. I believe it's important that we learn more about how ICANN affects all of us, both the key players in the Internet world, but all Americans, all people around the world who use the Internet. And I'm interested in hearing how it affects the organizations that are represented here today. Again, I thank the witnesses and look forward to your testimony.
Thank you very much, Mr. Shadegg. The gentleman from New York, Mr. Weiner, is recognized for 2 minutes.
Mr. Chairman, in the interest of hearing from the panel, I'll relinquish my time for opening statement.
Thank you very much, Mr. Weiner. We now turn to our panel of witnesses, and we welcome each of them to the subcommittee this morning. I'll just say a brief word of introduction with respect to each. Ms. Fiona Alexander is Associate Administrator in the Office of International Affairs at the National Telecommunications and Information Administration. In that position, she is the primary liaison between the department and ICANN. Dr. Paul Twomey is President and Chief Executive Officer of ICANN. Mr. Kenneth Silva is Senior Vice President and Chief Technology Officer for VeriSign, the registry for the .com top-level domain. Ms. Christine Jones is the General Counsel and Corporate Secretary for GoDaddy. Ms. Sarah Deutsch is Vice President and Associate General Counsel for Verizon Communications. And Dr. Thomas Leonard is President and Senior Fellow of the Technology Policy Institute. We welcome each of our witnesses, and without objection, your prepared written statement will be made a part of the record. We will welcome your oral summaries, and we would ask that in the interest of time and giving us plenty of opportunity to question you, that you keep those oral summaries to approximately 5 minutes. Ms. Alexander, we'll be pleased to begin with you.
Chairman Boucher, Ranking Member Stearns, and members of the committee, thank you for this opportunity to testify on behalf of the National...
Ms. Alexander, if you could pull that microphone slightly closer, we can hear you better.
Better?
That's better, thank you.
Chairman Boucher, Ranking Member Stearns, and members of the subcommittee, thank you for this opportunity to testify on behalf of the National Telecommunications and Information Administration on issues related to the Internet's domain name and addressing system. The Internet has become a significant and important medium for conducting research, communicating with others, and conducting business. Given the Internet's importance in all of these facets of daily life and the country's general economic well-being, it is essential that the Internet and its underlying infrastructure remain stable and secure. Consequently, the Department of Commerce takes very seriously its responsibilities with respect to the Internet DNS, including the joint project agreement between the Department and ICANN. ICANN was created out of an effort to bring more coordination and sustainability to the management of the Internet DNS as Internet grew into a large-scale global network. A 1997 executive memorandum directed the Secretary of Commerce to privatize the Internet DNS in a manner that increases competition and facilitates international participation in its management. In June 1998, the Department issued a statement of policy on the privatization of the Internet DNS and concluded that the core functions should be primarily performed through private sector management. ICANN was formed by private sector interests for this purpose, and in the fall of 1998, the Department of Commerce entered into a Memorandum of Understanding, or MOU, with ICANN. The MOU did not simply turn over management of the DNS to ICANN. Rather, the purpose of this agreement was to design, develop, and test mechanisms, methods, and procedures to ensure that the private sector has the capability and resources to assume important responsibilities related to the technical coordination and management of the DNS. This agreement does not give the Department of Commerce the ability to exercise oversight in the traditional context of regulation, and we play no role in the internal governance or day-to-day operations of ICANN. Since 1998, the MOU has evolved through several iterations and revisions as ICANN tested these principles, learned valuable lessons, and matured as an organization. In 2006, NTA and ICANN signed a joint project agreement extending the current MOU for 3 more years until September 30th of this year. In anticipation of the September 30th expiration of the JPA, NTI released a notice of inquiry on April 24th seeking comments regarding the progress of the transition, as well as the model of private sector leadership and bottom-up policy development which ICANN represents. The comment process for this docket closes on Monday, June 8th. The Department's commitment to preserving the security and stability of the Internet DNS and the public record developed as a result of this comment process will inform any decision about the JPA's future. It is important to note, however, that regardless of whether the JPA is terminated, modified, or extended, the Department, through NTIA, will continue to be an active participant in ICANN by representing the United States government in ICANN's Governmental Advisory Committee and by filing comments, as appropriate, in ICANN's various public consultation processes. In addition, the Department's relationship with ICANN will continue as ICANN currently performs the Internet Assigned Numbers Authority functions under contract to the Department. In addition to important institutional confidence issues associated with the JPA, the Department is actively engaged in discussions with stakeholders related to introduction of new generic top-level domain names, or gTLDs. The Department acknowledges that the introduction of new gTLDs has been a long-standing goal of the JPA relationship and the subject of ongoing public consultation process at ICANN. The Department, in coordination with an interagency group, has in fact filed public comments in this consultation, asking if the threshold question of whether the potential consumer benefits outweigh the potential costs as a result of this exercise, and had been adequately addressed and determined, and recommending further economic study of the issue as called for by the ICANN board. The department also identified a series of initial items that needed to be resolved prior to moving forward, including expanding the marketplace before effective and meaningful tools are in place to protect consumers and brand owners, as well as the need to preserve the security and stability of the DNS. The department believes it is critical to keep in mind the core principle, as articulated in the very first MOU, of the need to manage the Internet DNS in a manner that permits market mechanisms to support competition and consumer choice, so that lower costs are realized, innovation is promoted, and user choice and satisfaction are enhanced. Lastly, I would like to take this opportunity to update the committee on our efforts to improve the security of the DNS. I'm happy to report that NTIA and its root zone management partners, ICANN and VeriSign, recently reached agreement to move forward with an interim approach to the deployment of a security technology known as Domain Name System Security Extensions, or DNSSEC, at the root zone level. This action is an important step toward protecting the integrity of DNS data and mitigating attacks such as cache poisoning and other data modification threats. Given the importance of the Internet as a global medium to support economic growth and innovation, continuing to preserve the security and stability of the Internet DNS will guide any decisions that the Department of Commerce makes with respect to its future relationship with ICANN. NTA looks forward to working with you, members of the committee, and the Congress on this important issue as the September 30th, 2009 JPA expiration date approaches. Thank you again, Mr. Chairman, for this opportunity to testify this morning. I'll be happy to answer your questions.
Thank you, Ms. Alexander. Dr. Twomey.
Thank you, Chairman Boucher, Ranking Member Stearns, and esteemed members of the committee. Thank you for this opportunity to appear before you today and to speak about both the Joint Project Agreement conclusion and new generic top-level domains. The Joint Project Agreement Memorandum of Understanding process has helped to grow ICANN to be a remarkable success story. The unique US government-ICANN relationship has been, is, and will continue to be critically important to ICANN's success. The original Memorandum of Understanding used the word test when it was commenced almost 11 years ago. It was a test of whether a multi-stakeholder, private sector-led, California-based not-for-profit corporation could perform a narrow but crucial technical coordination function. After those 11 years, ICANN is a successful US-based organisation with global support and participation. It has been key to supporting a single, interoperable Internet on which 1.5 billion rely. In simple terms, it works. It has passed the test. Like other organisations, it must continually improve itself. But unlike many, this organisation has continual improvement written into its bylaws. It also has an assertive community that keeps driving us to improve and will never allow us to stop striving for the best that we can be. We're not seeking less accountability to this multi-stakeholder community. We want more. The question at hand is how to ensure that what works is made permanent. One thing the Joint Project Agreement is clearly not is an oversight mechanism. And Ms. Alexander has just pointed out again that the Department of Commerce has consistently said that the JPA is not an oversight agreement. Chairman Boucher, you made the point in your introductions about the ICANN contract, the procurement contract. This is the key instrument for oversight from the United States government. And I think you already will have potentially some misapprehensions about the difference between the Joint Project Agreement and the ICANN contract is something we should explore. What we've been working together on for 11 years with advice from the United States government is a model all about private sector, bottom-up partnership with guidance from government. This is the time to have confidence to state this model works. Any new instrument, no matter how temporary, implicitly says that we, the United States government, and ICANN, don't have the confidence in that model. That will cause the international community to continue to look for alternatives. Indeed, with the mere speculation as to the possibility of renewal, they already are. If the US does not have the confidence in a private sector-led model, we should not expect other governments to have confidence in the model. If we continue to question the private sector-led community's ability to lead itself through the ICANN model, we should expect ongoing challenges and alternatives from others. A hypothetical 8th temporary agreement would suggest that the basic principles are open to debate. Across the global technical, registry and governments community, the question I get posed regularly is, does the United States government agree with and have confidence in the private sector-led model? If the answer is yes, still yes, then let's confirm that and enshrine it. A more permanent approach that enshrines what is working is vital. As the JPA concludes, the Department of Commerce and ICANN should use that opportunity to commit ICANN to retain a narrow mission, remain based in the United States, remain a not-for-profit, remain an independent organisation as has been for almost 11 years, remain private sector, multi-stakeholder led with international support, remain committed to continuous improvement, reinforcing that they are ANA contract is the source of oversight, where responsibility for the global coordination of the DNS route, IP addressing and other resources is found. None of these should rely on any temporary agreement. And being a California-based organisation ensures ICANN is subject to congressional oversight and US legal process. Let me speak briefly to the issues of generic top-level domains, that portion of an internet address that is to the right of the dot, such as .com or .org. Currently, there are 21 gTLDs. ICANN is currently deciding how to lift that artificial limit. There are crucial concerns about trademark and intellectual property protections once the expansion of gTLDs begins, if that's decided. We've heard those concerns and we are acting to fix them. The ICANN board has invited those who have voiced concern to give us solutions before we open up the application process. We have already received their recommendations. We are focusing on other concerns as well to do with malicious behaviour, security and demand. And I can assure members of the committee that we will not move forward with any progress in implementation until we have addressed these issues. We will get it right. We will not rush the answer. We've often asked, why are we expanding the top-level domain space? First, we were asked to by the community and the United States government. It was called for in the white paper that foreshadowed ICANN, and it is in the JPA. Second, there is demand. Geographic names like .nyc and .berlin are being proposed along with others like .sport, .eco and .green. Finally, billions of non-English speakers want to see top-level domains look like their language. It is not ICANN's role to set artificial and arbitrary limits on innovation and community use of public resource. Simply, competition in the domain space is embedded in our values and our bylaws. So in conclusion, it's no surprise that the ICANN model is producing opportunities for choice, commerce and individual expression, and doing so while being attendant to our core mission, security and stability. The United States government has imbued these values into the ICANN model, and ICANN is made all the stronger for that. Thank you for inviting me, and I'd look happy to take any questions.
Thank you very much, Dr. Twomey. Mr. Silva.
Good morning, Chairman Boucher, Ranking Member Stearns, and other distinguished members of the subcommittee. My name is Ken Silva, and I serve as the Chief Technology Officer for VeriSign. Thank you for the opportunity to testify today. VeriSign operates digital infrastructure that enables and protects billions of interactions every day across the world's voice and data networks. The company is headquartered in Mountain View, California. We have additional offices in Virginia, Delaware, and Massachusetts. Because our responsibility is global, we're also in 30 different countries. At a time of economic challenges and uncertainty, it would be easy to focus on the many pressing near-term issues that affect our nation. But it is critical that we also focus on the Internet, because the infrastructure is not only integral to the economic recovery of our country, but our national security as well. As the operator of the .com and .net domain registries, as well as a steward for 2 of the 13 root servers that serve as the nerve center of the Internet, VeriSign understands what's at stake. Over the last 10 years, VeriSign has operated its infrastructure with 100% uptime. In other words, the systems that ensure the Internet is functional have never gone down. But the Internet is not a static system. It's a dynamic network of networks that continues to change. It's growing dramatically overseas, raising questions about its future governance and the role of nations who do not share our values about freedom of expression, content, and commerce. It is increasingly relied upon by citizens, businesses, organizations, and governments, raising questions about whether it can continue to scale to meet the needs of over 2 billion users in the future. It is a target of attacks that expand exponentially in volume, scope, and sophistication, raising questions about whether enough is being done to protect those critical networks that serve as the lifeline for commerce and communications. Recent incidents in China, India, Pakistan, and Estonia underscore that importance. I would like to address 3 challenges in my testimony: Internet governance, scaling of the Internet, securing the Internet. With respect to Internet governance, when it became clear that the Internet would have a profound impact on every facet of society, the Clinton administration took the lead in establishing ICANN to serve as the technical coordinating body. The Department of Commerce was given the task of helping guide ICANN and provide a governmental backstop. We must consider how to ensure that the Internet and the community that guides it are insulated as much as possible from domestic political pressures or the goals of those in the world who want to restrict what has made the Internet so dynamic, namely, its innovative force and capacity to create businesses and jobs. With that, we look forward to the outcome of the discussions between ICANN and the Department of Commerce over the JPA, particularly as it relates to its impact on the security and stability of the Internet and its responsible stewardship. From our point of view, while ICANN has continued to make progress in certain areas, the basic circumstances giving rise to widespread community concerns over an expiration of the JPA remain largely unanswered. The overall goal in this process must be the strengthening of the security and stability of the Internet. With respect to scaling the Internet, because .com and .net never go down, users and even some companies who rely on it for their business model take it for granted. But VeriSign, other private sector players, and government cannot. We must continually invest and work to improve in its capacity. To keep up with the demand, VeriSign systems that manage .com and .net traffic can now handle more than 10,000 times the query volume that they could handle in 2000. To put that in perspective, that increase is about 600 times greater than Moore's Law, the theory that computing power doubles every 18 months. VeriSign systems handle more than 50 billion queries a day, and that's a 67% increase in just 2 years. Our investments include increasing capacity to support up to 4 trillion queries per day. We all know that the Internet that we use today is far different than it was 10 years ago, and we know that 10 years from now it'll be dramatically different than it is today. That's why VeriSign is continually investing and looking into strengthening that infrastructure that we all rely upon. With respect to securing the Internet, we are pleased that President Obama's cybersecurity czar will sit at the National Economic Council and the National Security Council as it underscores the threat that cybersecurity attacks pose to our nation. As CTO, I've had to identify and manage attacks every day. Cybercriminals cleverly manipulate the Internet's advances, and the increased bandwidth and computing power available to them literally gives hackers more ammunition to utilize against the infrastructure. There are many issues that we must address as an Internet community. We must continue to invest and deploy in infrastructure upgrades such as DNSSEC and IP version 6 in a way that is least disruptive to Internet users, developers, businesses, and governments. We must continue to work together to invest and develop in the infrastructure so that it can continue its role as a platform for commerce and communications. I know that VeriSign, ICANN, and the rest of the Internet community will work diligently to ensure that the infrastructure remains reliable and secure. I thank you very much for your time, Mr. Chairman.
Thank you very much, Mr. Silva. Ms. Jones.
Ranking Member Stearns and members of the committee, I'm Christine Jones. I'm from GoDaddy. At the outset, I'd like to thank you, Chairman Boucher, for all of your work and the committee's work and for holding this hearing. We're happy to be here with ICANN and VeriSign. We're ICANN's largest registrar benefactor and VeriSign's largest customer, so we're always happy to participate with them. As the world's largest registrar, GoDaddy works daily with ICANN in its role as the coordinating body for the Internet. We believe it is essential for world commerce, as well as the security and the stability of the Internet, that the relationship between the NTIA and ICANN be continued, along with appropriate improvements in accountability, transparency, and democracy and governing principles. Continuing the JPA between ICANN and the NTIA will not only provide the framework for ensuring a continued focus on Internet security and stability issues, but will prevent ICANN from vulnerability to capture by another government, international organization, or business that does not have an open, secure, and stable Internet as its top priority. On the renewal of the JPA, the DNS white paper, first published back in 1998, articulated that principles of accountability, competition, private bottom-up coordination, and representation are necessary for guiding the transition to a private sector management of Internet DNS. We believe those principles, even 11 years later, remain relevant. ICANN has made great progress toward achieving some, but not all, of these goals. Specifically, ICANN has not yet achieved competition, nor the private bottom-up coordination and representation called for in the ICANN bylaws. We believe the renewed JPA must be revised to include openness and transparency as overall guiding principles if we're ever to see an effective transition of Internet DNS management to the private sector through ICANN. And of course, we would be happy to be involved in the process of determining appropriate revisions to the JPA if such assistance would be helpful. I want to talk about the extension of the JPA that you mentioned, Mr. Chairman, for a minute. I want to reiterate, we are in favor of renewal of the JPA between ICANN and the NTIA for a multitude of reasons, not the least of which are a failure to accomplish its mission and abide by its stated core values. We believe ICANN will benefit from continued relationship. But we're aware that both VeriSign's ex parte letter and the recent letter from Senators Nelson and Snowe mentioned considering a one-year extension of the current JPA. If that arrangement would provide time to consider new or additional terms of a renewed JPA, then we would support such an extension as well. On the new gTLDs, we're not opposed, GoDaddy is not opposed to the concept of introducing new gTLDs. In fact, as Mr. Twomey said, the community has been calling for that for quite some time, but we have taken exception to the methodology by which they've been introduced. Loud voices from both the intellectual property community and the registrant community have been virtually ignored in this process. And ICANN can't seem to establish a guideline by which the new gTLDs will be chosen. In the interest of time, I'm going to defer to the IP expert on this panel to talk about gTLDs, but I'd love to get back to this if anybody asks questions on it. I want to focus on security and stability, because like all of us at this table and in this room, GoDaddy believes that security and stability of the internet is vital. Indeed, we devote a considerable amount of time and resources to working with law enforcement on preserving the integrity and safety of the internet. By quickly closing down websites and domain names engaged in illegal activities, we work with law enforcement agencies at all levels and routinely assist in a wide variety of criminal and civil investigations. And, like our friends at VeriSign, we respond to and fight cyber attacks on our hosting, email, and domain name systems every single day. I personally, and this company in general, have made it a high priority to use our position as the world's largest registrar to make the internet a better and safer place. And we could not agree more with President Obama's decision to make cybersecurity and internet privacy issues a top priority in his administration. As the president said on Friday, America's economic prosperity in the 21st century will depend on cybersecurity. This is also a matter of public safety and national security. It's now clear the cyber threat is one of the most serious economic and national security challenges we face as a nation. We wholeheartedly agree. So thank you again, Mr. Chairman, for holding this hearing. We are in support, again, of the extension of the JPA. I would be happy to answer any questions for you or other members of the panel. Thank you.
Thank you very much, Ms. Jones. Ms. Deutsch, we'll be happy to hear from you.
Yes. Chairman Boucher, Ranking Member Stearns, and members of the subcommittee. Thanks for the opportunity to participate in this important hearing addressing issues related to ICANN. Verizon supports ICANN. We wish to see it succeed as an independent and accountable model of private sector leadership. ICANN must be given the time and support it needs to make that smooth transition. My focus today is on ICANN's plans to expand the existing domain name space. ICANN plans to accept as many as 500 initial applications for new generic top-level domains, or gTLDs. I will refer to gTLDs simply as names. In the future, there may be unlimited number of new names. Future names could include anything one could imagine, from .bank to .health to .congress. ICANN financially benefits from this expansion. It will bring in more than $90 million from the initial round of applications alone. It will also collect ongoing fees of $75,000 per applicant from annual renewals of each new name. And it collects a 25-cent transaction fee from every domain name registered. As a result, however, businesses and consumers will face higher costs. This isn't very helpful in the current economic climate. Hundreds of diverse parties, including consumer groups, business organizations, trademark owners, and internet security experts, have raised concern. ICANN has acknowledged the many concerns, but it has not adequately addressed them. Nevertheless, it plans to begin accepting applications for the new TLDs starting in early 2010. Verizon believes there are 4 fundamental concerns that ICANN needs to address fully before commencing any introduction of new TLDs. First, ICANN must complete an impartial and comprehensive economic study of the domain name marketplace. That study must explore whether there isn't even a need for so many new names in the first place. ICANN's board supported that study in 2007, yet it was never undertaken. Second, ICANN must ensure that consumers are adequately protected from online confusion and fraud. If, as predicted, there are more than 1,000 new names in the next 3 years, consumers will be the victims of more online confusion, more fraud, and more malicious activity. Consumers already have difficulty today finding the legitimate websites they want to reach. So consumers must be confident when they go to Verizon.phone, for example, that they've reached an authorized Verizon website versus one set up by a cybersquatter or an international phishing scam. Third, ICANN's rapid expansion may be at odds with its responsibility to increase the long-term safety and stability of the domain name system. ICANN may not have the ability to manage such a rapid expansion. Fourth, trademark and brand protection remain a critical concern. Trademark protection, of course, is directly tied to consumer protection. Trademarks help consumers reach the websites and brands they know and trust. When users go online, however, they can easily be confused or diverted. And unfortunately, brands like Verizon, household brands, have been targets for cybersquatters. Cybersquatters have registered tens of thousands of variations of our trademarks over the past few years, and here's a little stack. You need to know that many of these cybersquatters are ICANN-accredited registrars. They've set up large-scale operations earning millions of dollars a year from their illegal activities. To protect our customers, we've brought many high-profile lawsuits against ICANN registrars in recent years. ICANN's registrars contractually agree to comply with all laws. Yet, we have observed little, if any, enforcement by ICANN against registrars who are found to violate anti-cybersquatting laws. We are very pleased that ICANN acknowledged the concerns raised by trademark owners by convening a small group of experts to offer possible solutions to address cybersquatting in an expanding gTLD space. We urge ICANN to adopt all these proposals as a package and continue to work with trademark owners on improving them. Verizon has specific ideas for such improvements, as discussed in our written statement. In sum, any new TLD rollout must be delayed until all threshold concerns are fully addressed. ICANN should proceed slowly and cautiously in expanding the domain name space to protect the Internet and its users. Finally, one note on the JPA. Numerous thoughtful suggestions have been made to improve ICANN processes while still preserving the model of private sector leadership. It is important to allow sufficient time to consider and implement these suggestions as well. We commend the subcommittee for addressing this important subject. Thanks again for the opportunity to testify.
Thank you very much, Ms. Deutsch. Dr. Leonard.
Thank you, Chairman Boucher, Ranking Member Stearns.
And Dr. Leonard, if you could turn on your microphone and move it over, that would help us hear you.
Thank you, Chairman Boucher, Ranking Member Stearns, and members of the subcommittee. My name is Thomas Leonard, and I'm President and Senior Fellow at the Technology Policy Institute. TPI is a nonpartisan, nonprofit think tank that focuses on the economics of innovation, technical change, and related regulation in the United States and around the world. I appreciate the opportunity to present my views on ICANN. The expiration of the JPA this September provides a much-needed opportunity for a thorough evaluation of the structure, governance, and mission of ICANN, and the subcommittee's examination of these issues is very important. One of those issues is ICANN's lack of accountability, which is a recurring issue, and which is an issue that we recently addressed in a study that was published by TPI that I co-authored with Professor Lawrence White of the NYU Stern School of Business. The problem of the lack of accountability is not an indictment of ICANN's staff or leadership. It's simply a function of ICANN's institutional design. Its non-corporate corporation status combined with the way it's funded and governed. ICANN's customers have nowhere else to go. Its board members are not answerable to any shareholders, and its decisions can't be appealed to any court in the way that regulatory decisions in the U.S. routinely are. ICANN's funders, the registries and the registrars, can't stop funding ICANN without going out of business themselves. To study ways in which ICANN could become more accountable, we examined the structures of a number of organizations that perform similar coordination and standard-setting functions. we learned a couple of things. First, none of the organizations we considered operates with the independence that ICANN enjoys, even under the current nominal oversight by the Department of Commerce. In addition, virtually all of these other organizations are governed by their direct users, thereby building accountability into their structures. We believe this would be a good model for ICANN as well. The registries and the registrars have a strong incentive to assure that ICANN fulfills its responsibilities of managing the domain name system efficiently, and this is in the interest of the businesses and the consumers who are the Internet's end users. We recognize that this proposal may be viewed as radical, but it has already served to stimulate a discussion of ICANN governance issues that otherwise might not have taken place. Our study also addressed ICANN's mission. ICANN's scope should be clearly delineated. It should hew closely to the technical functions in administering the domain name system. ICANN also, we believe, should have a clear mission of encouraging competition and a minimal role as a regulator. This means allowing relatively free entry into the market for gTLDs in order to bring the benefits of competition to consumers, and as we've heard, ICANN is moving in that direction currently. But as part of this, in order for the free entry of gTLDs to work well, protections for incumbent domain name holders must be strengthened so that they are not subject to nuisance or ransom demands from new registries. There needs to be a thorough examination of how this should be done and who should do it. As was alluded to, ICANN is doing that now. But ICANN is not particularly well equipped to be a regulator and probably not particularly well equipped to be an adjudicator of intellectual property disputes. Issues as important and complex as these merit a thorough evaluation, which probably cannot be completed by September. Therefore, we believe that the agreement with the Department of Commerce should be extended in some form beyond its current expiration date while reforms are being considered and hopefully becoming established. Reforming ICANN in a way that makes it truly accountable and clearly defines its scope of operations will ultimately make it feasible to end the JPA and, more importantly, ensure a vibrant, innovative, and competitive Internet for the future. Thank you very much.
Thank you very much, Dr. Leonard. Thanks to all of the witnesses for your informative comments this morning. Dr. Twomey, we're pleased to have you with us today, and thank you for taking the time to travel to Washington for purposes of this hearing. I know that many of the members in their questions are going to focus on the expiration of the joint project agreement, which occurs this September. So I'm going to take my question time this morning to focus on some other matters. And the first thing I would like to ask you to do is comment on the concerns that were raised by Ms. Deutsch when she talked about the tremendous volume of cyber squatting that is occurring and mentioned that some of the companies engaged in cyber squatting are actually accredited registrars who have been accredited by you. And I would like to get your response to the concerns that she has raised and an indication of what you're doing to police that practice, and particularly how you could propose to engage in effective oversight and policing, not only with regard to the existing top-level domains, but with the expanded responsibilities that would come for oversight and policing if you proliferate the number of TLDs, because that inevitably is going to mean that companies have to acquire more second-level domains, and that incurs cost on their part, and the opportunity for cyber squatting simply increases. And so, according to Ms. Deutsch, today cyber squatting is not effectively being policed, and that leads to an even heightened level of concern about how you would oversee and police if the number of TLDs increases. So with that general question, we'd welcome your answer.
Thank you, Mr. Chairman. We share the same general concerns Ms. Deutsch outlined. So there's validity. We don't dispute the validity of some of these concerns, but we also think there are mechanisms in place and mechanisms being discussed to help address these issues. Let me come quite specifically to enforcement mechanisms now. ICANN established and put in place now, I think 9 years ago, a process called the Uniform Dispute Resolution Process, which is essentially a fairly cheap online arbitration mechanism to allow contesting parties to determine who should actually own a particular domain name. One of the difficulties with cyber squatting, is one person's cyber squatter might be somebody else's true trademark, in the sense that there are 180-something regimes, jurisdictions in the world. There are some 48 trademark headings. I might be getting the exact numbers wrong, but the key point is that people can have multiple trademarks for different sorts of companies in different parts of the world who've got a valid claim for a particular name. So it's not ICANN's role to be an intellectual property arbitrator. What we have actually was put in place a mechanism for that sort of arbitration. The World Intellectual Property Organization and other entities offer that arbitration. And I think so far there's been some 36,000 decisions made under that regime we have incorporated to help address those issues presently at the second level. There's a similar issue applies then at top-level domains, and we have proposed that there'd be a similar arbitration mechanism people could object to when a first application was made, so that you could say, no, I've got a claim on that name, or that's related to me. And so there's an existing mechanism put forward for arbitration. Thirdly, we're very much interested in these proposals put forward recently by the intellectual property community at the request of the ICANN board for looking at variations of sunrise periods, single registration periods for companies who want to be clear about their famous names, etc. So we're actually looking to address this quite detailed. We'd like to hear the response more in the community for the proposals they've put forward. When it comes to the issue of enforcement of registrars, which you've raised, we have a significant resources dedicated to enforcement. We have been I think if you looked in the last months, I think nearly every month we have de-accredited registrars for various breaches of their agreements. And this issue of whether a registrar is actually performing blatant cybersecurity or blatant cyber squatting activities is a matter we investigate quite closely. But I would make the point on some cyber squatting issues that it's not our business to be an arbitrator on intellectual property contention. We actually have that, if you like, with a set of independent arbitrators for them to give us that advice.
Ms. Deutsch, would you like to respond to those comments? And I mean, you've heard how Dr. Twomey would address the issue of cyber squatting, and he's defined current practice. To what extent is current practice not adequate?
First of all, we're not saying that it's ICANN's role to arbitrate the proceedings. On the other hand, it is its role to enforce against its registrars. And to my knowledge, they haven't brought any action against a registrar. These are registrars who have been found by federal courts or by this same World Intellectual Property Organization, sometimes on hundreds of occasions, have been found to act in bad faith. So they have taken no action against them.
Well, let me stop you at that point. Dr. Twomey, what is your reply to that? Have you ever proceeded against any of these certified registrars because of their activities?
From my recollection, Chairman, we have proceeded against registrars for those activities. Often we find with a particular registrar that if they're in breach along those lines, they're in breach in other ways. And sometimes to move quickly on the de-accreditation process, we have publicly moved on another breach. If I can give you just a small example and an easy example you'd understand, often we find registrars who might be at the edge of such behaviour, for instance, don't pay their fees. And sometimes it's easier simply to move on the failure to pay a fee. We can clearly prove it very quickly and move on the accreditation. But I can report to you in the compliance activity this particular issue is often examined, and that in a lot of the communications with the registrars, particular issues that's raised.
Well, I find the issue of enforcement against cyber squatting to be particularly troubling, and I think it might be helpful to the subcommittee, because other members have raised this concern as well, if you would supply to us a letter that describes exactly what you're doing in this area, and perhaps without naming particular registrars that you may have proceeded against, give us at least some quantitative sense of the extent to which you have addressed this concern. Actual numbers of proceedings, perhaps numbers of registrars that have been decertified where cyber squatting, in fact, has been alleged. I think that would be helpful. My time has expired. We may, depending on how long this first round takes, have a second round of questions. I do have some additional ones. But at this time, I want to recognize the gentleman from Florida, Mr. Stearns, for 5 minutes.
Thank you, Mr. Chairman. Mr. Leonard, you'd mentioned in your opening statement some fees. I see here that registrars pay an application fee of $2,500, annual accreditation fees of $4,000 each. You mentioned some $75,000 fee, I thought. Did you mention that in your statement, opening statement? Just put the mic on, if you would.
It's not in the opening statement. It could be in our report, but I'd have to get back to you.
Yes, Ms. Wood.
I mentioned it.
Yes, what was that for?
I think it's an annual renewal fee for the new TLD applicants. So once they get awarded one of these names, then every year thereafter, I understand they pay a $75,000.
That sounds pretty steep to me. Doesn't it sound to you, Ms. Story? Yeah. Now, Mr. Twomey, ICANN had a $7 million surplus in 2009. And you add these new TLDs, you could generate another $90 million. Yet you're a not-for-profit organization. Why don't you take less profit and these fees, bring these fees down for the registrars and for consumers and operate as a not-for-profit? You're operating as a for-profit corporation, and your profits are going to balloon based upon these TLDs. So why aren't you folding? I mean, you're not building automobiles here. You're trying to make it cheaper for people. Why aren't these fees coming down?
Thank you, Mr. Stearns. Perhaps I can clarify some of the issues raised here. ICANN is, as you said, a not-for-profit, and our focus is to
No, you don't have to tell me that. Just tell me,
Sorry.
why can't you bring your fees down if you got a $7 million profit?
That's fine. Let me just talk to the point. We are in the process of, our budgeting process is an open process we do through the community. It's a bottom-up budgetary.
What are you going to do with the $7 million profit?
And the $7 million process is a contribution to a reserve fund.
And what do you need a reserve fund if you're not for profit?
We have taken advice from, if we look at most non-profits, that they all have some reserve fund.
How big is your reserve fund going to be? How big is it today?
It's about $34 million.
So you got $34 million, and you're adding another 7 to it. That'll bring it up to 41.
And our aim is to bring it to 1 year's operating expenses and then stop the process of building the reserve fund. So we're not, and I can make the further point that we have actually reduced our fees by 25% in the last 3 years in applications. And that the
Ms. Deutsch, do you think their fees should be brought down?
I do. I think they have.
Mr. Leonard, what do you think?
Yeah, I mean, I think.
Do you think they want to have? They're now at $41 million surplus.
I think it's an organization with an assured source of income. It's not obvious to me why they need a full year's.
Now, Mr. Twomey, when I look at your annual report, it looks like your salary is. You don't even take a salary out of this. You've arranged for Argo Pacific to be a consultant, so that ICANN pays Argo Pacific your salary, then you collect from them. Why do you do that? Why don't you collect money like the CFO and everyone else in ICANN gets directly from ICANN, but you seem to get it from a consultant? Why is that?
Well, Congressman, I'm an Australian citizen, and we have arrangements with various parts of our employees through different mechanisms. When I was first asked to be president and CEO, the decision of the board then, this is all decided by the board, not by me, was to contract with a company.
That was a recommendation then?
That's right.
And do you live in Marina Del Rey?
My home is in Sydney, Australia.
So do you ever show up in ICANN's headquarters?
Yes, we have offices in.
I mean, do you work there 40 hours a week?
I work more than 40 hours a week in various ICANN.
In Australia, but I mean, are you actually?
No, I would be in Australia less than 1 week out of every 4.
When you do the exchange rate, what is the total salary, including the health, retirement, saving, and welfare benefits that you get when you do the exchange with Australia? What is in Australian dollars?
In Australian dollars, it's about $800,000 total.
800,000 is what you get. Well, my concern is, and I don't have a lot of time here, but it seems to me that if you're operating a not-for-profit and you're paying a CEO like you and a subcontract out of a corporation, that your job is to bring the cost down for the consumers and the registrars. And I just, in light of the fact that Mr. Boucher talked about the 4 things that Ms. Deutsch talked about, I don't see you attacking these. You should take that $7 million and to make sure the cyber squatters are gone. And she gives a list there, it looks like about 10,000 cyber squatters. I mean, why don't you take some of this surplus that you're getting and do the job? I think your job should be not just developing a surplus, but actually implementing, making it cheaper for consumers, and actually doing your mission, which is some of these 4 things that Verizon's talked about. Dr. Leonard, anything you'd suggest more? I mean, this idea that he's developing this huge surplus in this not-for-profit organization, I mean, that just doesn't seem appropriate considering Ms. Deutsch talked about $75,000 for a fee.
Yeah, I mean, I think it's related to the general issue of accountability and the fact that ICANN is largely accountable to itself.
So it could make the surplus 4 times that if it wanted. Yeah. Thank you, Mr. Chairman.
Thank you very much, Mr. Stearns. The gentleman from Michigan, Mr. Dingell, is recognized for 5 minutes.
Mr. Chairman, thank you. This question to the panel, yes or no answer. Ladies and gentlemen, the results of the midterm review of the joint project arrangement between NTIA and ICANN completed in February 2008 indicated that further work was required to increase institutional confidence in ICANN. These areas included long-term stability, accountability, responsiveness, continued private sector leadership, stakeholder participation, increased contract compliance, and enhanced competition. Has ICANN to date adequately addressed these concerns? Starting with Ms. Alexander, yes or no?
Thank you very much, Congressman. Given that we have an open proceeding on this
Just yes or no.
particular issue, I'm not in a position to answer yes or no with the open proceeding.
Next panelist, yes or no?
I would say yes in need of respect.
Next panelist,
I would say no.
next panelist.
No, sir, Mr. Chairman.
Thank you. Next panelist.
No, sir.
No, sir.
Ms. Alexander and the other panelists, again, if JPA terminates and is not extended, does NTIA, do you have concerns about the ability of ICANN to ensure stability and security in the Internet? Yes or no?
Yes, thank you very much, Congressman. Again, given the fact that we have an open
I'm sorry to do
proceeding.
it, but my time is limited and I've got a pile of questions here. Sir? Yes or no?
No, I think it has little impact.
Next panelist.
I would say that I have concerns about security and stability.
Next panelist.
Yes.
Next panelist.
Yes.
Next panelist.
Yes.
Now, recently in view of reports that the U.S. government has been subject to cyber attacks from abroad, does the department, do you believe that upon expiration of the JPA, the U.S. government will have adequate input into ICANN's efforts to ensure the stability and the security of Internet? Again, yes or no? If you please.
Thank you very much. Security and stability is what will guide the Department of Commerce in all of these areas.
Next panelist.
Yes, comprehensively, because it's not covered within the JPA detail to start with.
Thank you. Next panelist.
I don't know the answer to that definitively, but I would share those concerns.
Next panelist.
Yes, we would continue to have concerns there.
Thank you. Next panelist.
We would as well.
I agree. We would have concerns.
Now, NTI, this to Mr. Silva. As permitted under its contract with ICANN, VeriSign raises prices and that it charged for the .com registry in 2007 and 2008. For what reason did VeriSign do so?
Sir, specifically, these fee increases were used to invest in the infrastructure and to build that out. As a matter of fact, we've publicly stated we created a project called Project Titan, for which we're investing over $100 million in fortifying that infrastructure globally, not just adding dots on a map, if you will, but also increasing the capacity at each of those locations. When you look at some recent events, such as what happened to Estonia, what's happened recently in China specifically, part of those were DNS attacks, which were designed specifically to take the entire country's economic system down. We want to make sure that that doesn't happen to .com.
Thank you. Similarly, does VeriSign plan to raise its prices again in 2009? Yes or no?
I'm not in a position in the company to answer that question, yes or no.
You
That's not my role in the company.
All right. Ms. Alexander, allegations have been made that the 6-year contracts agreed upon in 2006 between ICANN and VeriSign for the registry of the domain .com suffers from lack of transparency. Upon review, does the Department of Commerce share this view? Yes or no?
Thank you very much, Mr. Congressman. The department did, in fact, approve this agreement in 2006 after consultation with the Department of Justice and other national security agencies, and also registrars, ISPs, and trade associations. Based on those consultations, we actually amended our cooperative agreement with VeriSign to retain the right to approve any substantial modifications to those contracts going forward.
All right. Mr. Chairman, I have 2 more questions I think are very useful here. Ms. Alexander, given these allegations, does the department intend to ratify another agreement between ICANN and VeriSign on the expiration of the current agreement? Yes or no?
The agreement expires in 2012, and at that time, when the information is presented to the department, we will once again conduct a fulsome review of that, discussing with the Department of Justice, other stakeholders, and figuring out the best way forward.
Thank you. Now, other panelists, if you please, let's return to the earlier question. Allegations have been made that the 6-year contract agreed upon between ICANN and VeriSign in 2006 lacks transparency. Do you agree with that statement, yes or no?
The contract's on public record, so I don't agree with them.
I don't agree with that statement.
We agree that the manner in which the contract was negotiated lacked transparency, but inasmuch as the contract has now been published and we know what it says, I guess it's transparent now. We don't necessarily agree with the outcome.
But it wasn't transparent earlier.
I'm sorry?
It wasn't transparent earlier.
That's correct.
Next panelist.
I'm unfortunately not an expert on that particular question, so I don't know the answer.
Next panelist, please.
Yeah, I'm not an expert on that contract either, so.
Mr. Chairman, I ask unanimous consent that I be permitted to write a letter to the panelists in making further inquiries, and that the record remain open so that both that letter and their response can be included in the record of the day.
Without objection, and other members, I'm sure, are going to want to propound questions to you as well. So as you receive those inquiries, making a prompt reply would be very helpful to us. And without objection, the record shall remain open until replies are received. The gentleman from Arizona, Mr. Shadig, is recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Jones, I'd like to begin with you. I believe you testified that GoDaddy would like ICANN to operate in a more transparent and accountable manner. How would you like to see that happen, and do you believe the JPA can be strengthened to achieve that goal?
I'll answer your second question first. Yes.
Okay.
There are a multitude of ways in which we think accountability can be improved. I'll give you an example. ICANN holds 3 open board meetings a year. The rest of their meetings of the board are done in private. We've repeatedly asked for those meetings to produce transcripts. It's a very simple black and white request. We can't get it. A couple of days after they happen, we can get an agenda, and a couple of days after that, we can get minutes. But we'd actually like to know what's going on in those meetings. That would be an example. The way they negotiate contracts with registries. We'd love to know what's going on in those meetings. Let's make them accountable for the decisions they make, particularly as they relate to the questions that Mr. Stearns asked about prices, what they're doing with their money, line items in their budget. I mean, we make requests for information. We basically get stonewalled. I could go on and on, but there are some basic fundamental things that we'd like to see. All of that can be and will be, if we have any input, written into the JPA in its new version.
Does ICANN set the standards by which you operate when you issue a name?
Generally, we're accredited by ICANN, and then we operate with a contract with, for example, VeriSign on a .com. And ICANN, I think its mission is to be a coordinating body. We don't expect them to issue rules, for example, about what we would do with internet content or domain name disputes, because we don't decide the outcome of those disputes. But we operate at their luxury. So in as much as they're our accrediting body, yes, they make the rules for us.
Dr. Twomey, can you tell me what steps ICANN has taken to address the concerns raised during the JPA midterm review that further work was needed to increase institutional confidence in ICANN?
Thank you, Congressman, and I appreciate your question. I do have to say, in response to the last answer you heard, I've got to be quite clear. It was just wrong. ICANN publishes its agendas for all meetings 7 days before the meetings. The board meetings, their decisions are released within 3 days, and within a couple of days after that, a full transcript of the board is released.
A full transcript of the board?
Full transcript of the board discussions. A transcript of the full details of the board discussion.
Well, wait. There's a difference between details and transcript. Is it a transcript taken like a court reporter, the gentleman here is taking right now, or is it a...
It's a comprehensive set of minutes.
It's a set of minutes.
A comprehensive set of minutes.
It is not a transcript.
But it's not just this decision, that decision. It is a full description of the intervention of each board member. So
I think we're familiar with board minutes versus a transcript.
No, I think our board
what
minutes
Ms. Jones said was they would like a transcript of the discussions that occurred and the reasoning that occurred. Board minutes summarize that rather than produce it in word-for-word discussion.
I'll be happy to share with you examples, and I will send them to you for you to make that judgment. In terms of transparency, we have 3 meetings a year. We have public meetings. We have the fully minuted and posted board meetings. We translate all our documentation into the five of the UN languages. We transcribe discussions at our meetings, full transcripts at the meetings. We have over 53 public consultations in 2008. We had one every week. We have an independent ombudsman. We have corporate blogs. We have a full bottom-up public comment. To come to your question of transparency, I think it's fairly...
I think you're still trying to respond to my question to Ms. Jones, and I asked you if ICANN had taken work or taken steps to increase institutional confidence in ICANN. I was asking you what steps you have taken, and I don't believe... or are these all steps you've taken since that midterm review?
Well, they're not. Many of these we had in place, but we've taken more steps on transparency. We've taken, we have produced in more detail our accountability, full description of our accountability processes. We have improved extensively the participation and openness of participation in meetings to make full online participation in all meetings. We have a proposal in front now to amend our bylaws to further expand our independent review mechanisms, including basically setting up expanding our independent review panel processes. So there's been a series of steps. Again, they're actually quite comprehensive, so I'd be happy to respond to those more in detail with you in writing.
Mr. Chairman, my time has expired, but I would like to allow the other panelists to comment on the steps that ICANN has taken since the midterm review. If there's anybody on the panel that would like to comment on those steps.
I'll comment. So again, we commend the progress that they've made. We don't disagree that he's sitting on top of a numerous page document that describes their accountability functions, that they publish minutes or detailed minutes from their board meetings. I think I said that in my answer before. But we still think, and we know from the current version of the JPA, that there are goals articulated in that document that they have yet to fulfill. Has progress been made in the last 18 months? Yes. Is there more room for progress to be made in the next 18 months? Absolutely. And that's why we feel like an extension today and a renewed version in the future will help define the progress that's yet to be made in the future.
Anybody else like to comment? Yes, Doctor.
Yeah, the other thing I would observe is that I think, although they get conflated in this discussion, I think there's a big difference between transparency and accountability. You can be very transparent and be totally unaccountable. And
Excellent point.
The way we have viewed accountability in the work we've done is basically accountability to some external party, which you can be very, very transparent and still not have that. So.
Thank you very much.
Thank you very much, Mr. Shadegg.
Thank you, Mr. Chairman.
The gentlelady from the Virgin Islands, Ms. Christensen, is recognized for 5 minutes.
Thank you, Mr. Chairman. My first question would be to you, Mr. Alexander. Do you, on the fees, in 2000, GAO conducted a review on the Department of Commerce's relationship with ICANN and noted that as a project partner with the department under the Memorandum of Understanding, ICANN is allowed to collect fees, but is limited to recovering only the actual costs. Does NTIA believe that the fees being charged by ICANN are consistent with the department's policy to allow project partners to cover only actual project costs? And are you concerned that the potential revenue to be generated by ICANN's proposal, which may exceed $100 million, do you believe that those fees should be limited to the actual cost of managing the new gTLDs?
Yes, thank you very much, Congresswoman, for the question. There are a variety of different fees that ICANN charges, and it's very difficult to, from the panel discussions, everyone's talking about different fees. But to the extent the question you're raising, yes, the department still believes that ICANN as a nonprofit should be charging fees that are consistent with what the costs are. And in our letter that we filed last year in the gTLD public consultation process, we actually raised this issue with the actual better explanation of the fee structure and disposition of excess revenues if there were to be any.
Thank you. Mr. Twomey, Dr. Twomey, on the accountability issue, you mentioned that just recently ICANN released proposals to establish a new independent review tribunal to review ICANN's board decisions. And one, I'm wondering why it took so long to recognize that need, but doesn't ICANN also, don't your bylaws already provide an independent review mechanism to review ICANN's board action, and has it ever been used?
Thank you. Thank you, Congresswoman. And you're quite right. We actually have a series of existing mechanisms for multiple series of accountabilities. On the particular one about appeals, we have an independent ombudsman, we have a board review process, we have an independent review panel, which is an independent arbitration mechanism that is presently being utilised by one particular party. So we are actually that's presently being utilised by one party. I should reinforce for all the members, we are under US law, and we have been accountable before the US courts on many occasions. So we get sued under US courts. The provisions I have pointed to you were further consultations we took from our community since the midterm review, with some further things we were putting in the accountability process. But I would also recommend to you and other members of the panel, to the committee, that as being a non-for-profit under the Californian law, we're also accountable to the Californian Attorney General. So we have multiple legal accountabilities already under the Californian Code, as well as under California, as well as under courts. So there's a range of those ways of being accountable.
Well, Ms. Jones, how would you respond to ICANN's argument that as a California-based not-for-profit, it's bound by state federal laws concerning contract, tort, and antitrust?
Well, I think every organization that's organized in any state is accountable to its state's attorney general. I don't think that's the point we're making here. And by the way, if I could respond to your earlier point about the independent review board,
sure.
Just we could throw in another acronym, but I'll try to forgo that
okay.
for your purposes. If the ICANN board appoints the members of the review board, it is by definition not independent and therefore not accountable. All of the review mechanisms we have in place right now, the ombudsman, the re-review, they're all ICANN reviewing ICANN. What we're saying is we want them to be accountable to the community. If we're going to have a community-based review board that's an actual international organization that can say the ICANN board made a decision and we're going to take a look at it and determine if it was appropriate or not, that's accountability, right? We shouldn't have to have somebody go to the Attorney General and make a complaint. They shouldn't have to go to the court and file a lawsuit. Why do we have to go there? Why do we have to have Verizon spending millions upon millions of dollars in litigation every year? It's not necessary. That board should be independent. It should be appointed by independent constituents and review the decisions without input from the board itself.
I tend to agree, but Dr. Twomey, you think it's independent? You're shaking your head.
Well,
I'll
I
give you
just
a
want
chance to respond.
again, none of those statements is just wrong. The independent review panel is not set by the ICANN board. The independent review panel's members are drawn by the International Centre for Dispute Resolution, an international arbitration body, and we follow traditional international arbitration mechanisms, so that we don't set the panel members whatsoever. The independent review arbitration body is the one who puts forward panel members. We don't.
Go ahead.
I just wonder if he can give us an example of when it's been used. And I know I'm not allowed to ask questions.
No, well, I think at the end of one of my questions, I asked if the independent review board that already exists has ever been utilized, and that'll be my last question.
Thank you, Congressman. As I said before, it is actually being utilised at the moment. We're actually actively in an arbitration in that review panel at the moment.
Thank you very much, Ms. Christensen. The gentlelady from California, Ms. Matsui, is recognized for 5 minutes.
Thank you, Mr. Chairman. Under the joint partnership agreement, the U.S. government affirmed its goals of preserving the security and stability of the Internet domain system. I want to focus on cyber attacks, mostly initiated abroad. They continue to pose a threat to consumers, businesses, and to government. Mr. Silva, in your oral testimony, you mentioned that a number of cyber attacks are initiated by individuals or groups in foreign countries like Estonia and Russia. Given the increase we're witnessing in cyber attacks globally and against the United States, critical infrastructure, it seems to me that many of our cybersecurity efforts tend to be more reactive and not proactive enough. The President's announcement this week of a newly created National Cybersecurity Advisor will certainly bring renewed focus and coordination on this issue. Is there anything the government can be doing, as well as consumers, to stay ahead of the latest techniques used by today's organized and sophisticated cyber criminals?
Thank you. I believe that in concert with the announcement that the President made was also a report that was published, which was the result of a 60-day review by Dr. Hathaway and her team. I believe that outlines some very positive steps that the government can take. And there were some good recommendations which I certainly support in that document. As for consumers, I believe that consumers first need to be educated on the issue. Unfortunately, cyber crime is something that always seems to happen to someone else until it happens to them. And it is unfortunate because they've probably already been a victim of it and don't even know it. In the confiscated machines of the attackers who have conducted phishing attacks or attacks where they have attempted to steal credit cards, the contents of those machines don't have tens of thousands of numbers. They have millions of numbers.
Okay.
So as far as consumers go and what they can do better, I think that will be the result. The outcome of that will be the result of a broader educational campaign, either through public awareness or through our education system.
Okay. Ms. Jones, in your testimony, you state that one of your major concerns is that ICANN is not adequately prepared to defend itself against cyber attack. What are some of your specific concerns about this?
The type of attack that we're talking about is the entire organization being taken over by another entity. And that could come in the form of an international organization, another government, some kind of other business. And that's not to say that they can't ever build a protection against being taken over, but we're just concerned that today, and I think even Dr. Twomey said this in his testimony, they need to establish a permanent, long-lasting set of principles upon which we can prevent them from being taken over. Now, I can tell you, if you take a look at the record from the WSIS round of talks, conversations about the UN or the ITU taking over ICANN, there are plenty of countries that aren't necessarily friendly to the open exchange of ideas, shall we say, to put it delicately, that would be very happy to take over this function.
Then let me follow up here. Dr. Twomey, what assurances could you provide us that the United States will always play a critical role with the organization, let's say if JPA is allowed to expire in September?
Excellent question. The first and foremost, and very importantly, is the IANA contract. The procurement contract is at the core of the link with the United States government with ICANN, because the actual operation of the IANA functions is at the core of what ICANN does. So that's the first and foremost the instrument. Secondly, as I said before, we are based in the United States, covered by United States law, covered by the purview of people like this committee as well. Thirdly, is that we have quite comprehensive interactions with the United States government as part of its one of the leading players in the ICANN government committee. And fourthly, because like any leading government, we need to be closely engaged. We have been heavily engaged, for instance, on cybersecurity issues, but also on other issues around competition, choice, and whatever. So there's multiple layers of that engagement. I have to say, that's one of the reasons why I actually make the point about the joint project agreement, which I think is a very different type of instrument, that if the joint project agreement expires, nothing changes. I think that's the key point we're trying to make, and I am concerned by some of the statements made today, is that if the joint project agreement expires, nothing changes in the way in which ICANN interacts and continues its role, or the importance of the link with the United States government.
Okay, I see my time's expired. I probably have some other questions in the second round. Thank you very much.
Thank you very much, Ms. Matsui. We have a series of 3 recorded votes pending on the floor of the House, and additional members who have questions they want to propound to you. We also probably will find the need to engage in a second round of questions propounded by the members who are here. And so, pending all of that, we're going to recess while these recorded votes are completed. We will ask for your patience. Please remain in the room or nearby, and the subcommittee will reconvene shortly.